My name is Chu Machinye, and I am your family lawyer. Under laws like the administration of estate laws, for instance of Lagos State, or the Wills Act of 1837, which is still applicable in some states, or the Wills laws of some states, only biological and adopted children can inherit under intestate succession. That is, if you died without making a will, your stepchild is not part of your estate and cannot inherit from it. There is no automatic inheritance for them. Nigerian courts have emphasized that customary law does not recognize stepchildren as heirs unless there is clear evidence of adoption or the community custom permits it. Where a step-parent makes a will, the law is that a testator has a right to dispose of their estates freely. A step-parent, therefore, can name a stepchild as a beneficiary in a will, granting them inheritance as they may deem fit. Where a stepchild is treated as a child during the lifetime of a person and depended on that parent, for example, for school fees, upkeep, and there is clear evidence of intention of that child to benefit from the step-parent, the court may weigh in favor of considering inclusion of that child, even when he is excluded by a will. Let's take a little peep at what Sharia law says for the benefit of our Muslim brothers and sisters. Stepchildren under Sharia law are not automatic heirs unless adopted or expressly provided for in a will, which is called wasiya under Islamic law, can allow for provisions by a step-parent who can bequeath up to 1/3 of their estate to a stepchild. Adoption under Sharia or Islamic law, as practiced in northern Nigeria, is fundamentally different from adoption under statutory law. Sharia does not recognize legal adoption in the Western sense, but it provides an alternative framework called kafala, or guardianship or sponsorship. The key features of kafala, guardianship under Sharia law, it will include some of the following. The child can be taken as a guardian, but that child does not take the surname of the guardian. The child does not automatically inherit from his guardian. The biological lineage of the child must be preserved. So at best, what happens under Sharia is a form of fostering rather than full parental adoption, because there is no assimilation into the family. Under kafala, a child cannot inherit as of right, but the guardian may provide for the child through a will and may give up to 1/3 of their estate to the child. Anything more must be approved by other heirs or given during the guardian's lifetime as a gift. So much for Islamic practice. Let us begin to round up this episode by showing you, telling you a few stories regarding adoption in Nigeria and how the courts look at them. In the first story I will tell you, someone was born to a woman in her maiden home after her marriage had broken down. Her brother, whose only child had left home and resided abroad, adopted that child as his son, and the child lived in the family house and enjoyed what is called mbala, the grandmother's homestead, that was given to his mother during her lifetime. Upon returning from abroad, the son of the man who adopted him sought to reclaim the mbala, arguing that under their custom, that child being born out of wedlock had no inheritance rights in his father's estate. They dragged the matter right up to the Court of Appeal, and the Court of Appeal did the right thing and decided that customary laws that deny inheritance rights to adopted children or those born out of wedlock are repugnant to natural justice, equity, and good conscience, and such customs are inconsistent with our Constitution, because our Constitution prohibits discrimination based on circumstances of birth. Thus, the court declared that custom void and affirmed that that child had a right to inherit from his adoptive father. The court emphasized that children should not be discriminated against in matters of inheritance. In another story that summarizes what we've been trying to explain to you regarding adoption, a certain person, a certain family, whom we'll call Mr. and Mrs. X, applied to adopt a child under the child rights law of Lagos State. They followed all legal procedures, including obtaining necessary consents and undergoing assessments by social welfare officers. After they had done this, the person from whom they were adopting the child began to play smart. But the court said no and highlighted that upon the grant of an adoption order, all rights, duties, obligations, and liabilities of the biological parents are extinguished, and the adoptive parents assume full parental responsibilities. The adopted child is entitled to all rights as if born to the adoptive parents, including inheritance rights. The court affirmed the adoption order and insisted that that child should be treated as a natural child of the adoptive parents, and that the biological parents no longer had any claim on that child. Collectively, what these cases and the laws we have cited to you have tried to show is that under Nigerian law, adopted children are entitled to the same rights as biological children, particularly concerning inheritance. Customs and practices that discriminate against adopted children are unconstitutional and should not be enforced. And where this is going on, someone should speak out. Someone should raise an alarm. Call a family lawyer when you see that this is going on. Generally, adoption in Nigeria is legally recognized and confers full parental rights and responsibilities on adoptive parents. The adopted child becomes equal in status to a biological child, except under customary or Islamic laws, where formal adoption may be limited or still unrecognized. Just like everything in life, today's episode of Your Family Lawyer must now come to an end. It might help someone in the situation we have discussed today. If you take a minute, just a minute or less, to like, comment, and share this video. But before we go, let me give you my final word for today. Stepchildren in Nigeria do not have automatic inheritance rights from step-parents under any of the three main legal systems, that is, statutory, customary, or Islamic. Certain criteria must be met for stepchildren to be entitled to inherit from their step-parents. First, they have to be formally adopted under the prevailing laws in the place where they live to be entitled to inherit, unless they are named in a valid will or there's a recognized local custom or judicial finding of intention or dependency. Let us hasten to add here that most ethnic nationalities, communities, towns, and villages have specific traditions and customs for adoption of children, and these customs are respected by the courts if they do not offend the Constitution of Nigeria, if they do not offend extant statutory provisions, or if they do not comply with equity, natural justice, and good conscience. Now you know all that you need to know about adoption, about the requirements for adoption and the procedure for so doing. You know what the law says of the status of adopted children and their rights and the rights of stepchildren in blended families. This should be all for today. Join me next Saturday on Your Family Lawyer, where we will continue to guide you through the laws that protect you and your legacy. Until then, please stay informed and, as always, be good to your family. My name is Chu Machinye, and I am your family lawyer.